The CPI report, vocal, victims of child abuse laws. You can watch our program here in Des Moines and the surrounding area close to Des Moines, all on Mediacom Channel 15. The program airs on Sunday at 1 o'clock p.m. Again, that program that we have produced comes on Wednesday at 9:30 p.m. For those that watch in the Council Bluffs, Omaha area, they can watch it on Cox Channel 23. It comes on out there every other Wednesday at 4:30 p.m.
You mean Thursday?
Do we may have a correction on that on the paper. Must be Thursday we should have. Sorry about that.
Yeah.
You can email us at vocaliowa@mchsi.com, especially if we have to have a correction like which day of the week it is there when we're producing it. Uh, anyway, we put out our telephone numbers. We've had many years of experience as parents and talking to parents. We give free advice. We're here to try to help and try to keep families together. That seems to be the opposite of DHS goal. My number is 515 276 3956, and John's number is 515 282 2672. My name is Don Burgmaier, and with me at the controls is my co host,
John Harvey, and welcome to the CPI report. That stands for Child Protection in Iowa. Yes, we do attempt to assist people who are having difficulties with the Department of Human Services and with the juvenile court. We're not attorneys, so we don't hold ourselves out to be attorneys, but we do attempt to offer advice and assistance when we can. In doing so, we know this takes an enormous amount of time. Now, the other major portion of our mission is to influence public policy as it relates to child protection issues. Right now, it seems as though public policy is doing a lot of very strange things. One of those strange things is happening in Iowa itself under a bill called House File 619 that was recently passed by the state legislature, and apparently it was passed without any thought. It restricts people from living within 2,000 feet of a school or from a daycare center. While it may, the intentions of the bill may have been valid, certainly the implementation and the design by which they were to separate children from or to try to add some level of protection for children was really nonsensical, because for a person and they call them sexual predators, to be kept away 2,000 feet as far as their dwelling is concerned makes no sense whatsoever. And your state representative, your state senator voted for it. So when you hold them accountable, next time around, when you hold them accountable at the voting booth, you can, when they get up and give their speeches about how they're going to do such great and marvelous things for you and your family, you can ask them, why did you vote for House File 619? It made no sense whatsoever. But it cost millions of dollars to run it. $5.3 million is what is currently budgeted for it, and that includes that does not include all of the unfunded mandates that are required for the police protection and all other associated efforts to implement the law. Now the police are going to have to knock on doors, try to find people, try to find out if they lived in their current residence for a given period of time, and then to instruct them that they will have to move in 3 days. Can you imagine someone asking you to pick up and go somewhere else to live in 3 days, particularly if the entire city is mapped out as to be a no zone for anyone who is on the Megan registry.
So you said you're, I guess, I'm just thinking, I'm doing this for the listeners there. You said House File
619.
Okay. And what is that?
Okay, what it is a reauthorization of a bill that they put through some time ago, and it was challenged, and in the 8th Circuit Court of Appeals, the challenge was finally put down, but in the meantime, they weren't able to enforce the law. Now they're going back to that original law. I think it was 2002, maybe.
Yeah, I think it was
2003.
2002.
Okay, and telling everyone all of the so-called sexual offenders. By the way, to be a sexual offender, you don't have to have committed a sex crime. It's simply any kind of a crime against a child. So if you backhanded a kid and because he was breaking into your house, that's a crime against a child, and you could be put on the Megan registry because that's a crime against a child. And if you were convicted of it, whether it's misdemeanor or whatever it was, I know a fellow who wrote a term paper, and because and he had permission from his professor to involve some of the content, which was pornographic in nature. But he did it because he was studying pornography. Well, now he is on the Megan registry, and had it not been for the fact that he already had secured his residence by several years, he could be moved from his current residence.
You say he was studying what?
I don't know what the
And that
course
was
was
a
he took.
college
It was a college course, and he had permission from his professor to do the subject matter of the term paper. So, and I don't regard him to be a sexual predator, but he will be treated as though he is a sexual predator. I know another fellow who shampooed the sand out of a little girl's hair, and 6-year-old girl's hair in the bathtub, and they turned that into be some kind of a sex crime. I don't regard that gentleman to be a sexual predator, but it really doesn't make any difference, you see, whether these people are eligible or fit the pattern. What they wanted is a sex crime law that could go after men, particularly. This one goes after women too, but the primary numbers come from the males in our state. So anyhow, we have established something that is going to be virtually impossible to enforce. Now, somebody who has lived in their neighborhood since 2002, or since before 2002, if they were a dangerous, violent predator, they can be permitted to still live there. Will that be of greater benefit to the children in the neighborhood simply because they have a grandfather clause? If they lived 2,001 foot from the school, would that be any less protection for the children? No, it's totally arbitrary, it's totally silly, and it's totally expensive to run a program like this. Well, some of these silly things are coming into law with no thinking behind it. I think that when we spend public funds to protect children, we ought to know that we're actually protecting children. Don, you had a comment.
I got a question for you. It, if oh, I forgot what I was going to say. Um, oh, yes, if a person is driven to suicide based on new laws that keep coming out against people, uh, will it be legal for them to live in the cemetery, or will that be too close to the schoolhouse?
Living in cemeteries don't go together.
Oh,
So,
okay, so it don't apply.
uh,
But
I-
it doesn't always mean it's a joke either, what these government laws do to a person.
I was mentioning one time on television that if you're sent to jail, you're within 2,000 feet of a downtown school, and therefore you'd be in violation taking up residency in the jail. Another silly thing is if you're
So you
homeless.
get another conviction while you're in jail.
That's right.
Oh, wow.
So I
They
don't-
got it all figured out.
Another thing is a situation where if you're homeless, where would you go? You go to a homeless shelter. Now, if you show up at the homeless shelter and the shelter is within 2,000 feet of a school, then they have to provide some kind of place for you somewhere else. So even homeless people don't have a chance when against a silly, poorly constructed law. It may have been well intentioned. I don't know how something that silly could have been well intentioned.
Well, even the road to hell is paved with good intentions.
That's right.
So, you know, and I'm all for preventing child abuse, but I mean, I could see the insanity in this law. It's kind of a big stretch to go from saying, you know, if you're a child abuser or such, they don't couch the language so that it's limited to that, but assuming that they did, it would be, I think, reasonable to say that they couldn't be near a schoolyard, okay? Unless they're picking up their own kids or something to that effect. But at the same time, how can you go from there to saying live within almost a mile or half a mile from, or a little bit over half a mile from the school? You know, or from a child care facility, which is everybody. There's daycare centers all over the place, especially the ones that are in people's homes. So when you factor that into the equation, you know, there's little to no place to live in most of the metropolitan areas in Iowa, and I think there was only one town that was exempt, which was Eli, which, according to an article that you pulled up today, John, I think it was not, you can't even live in Eli, according to these laws they're passing. So I guess we're going to have a lot of farmers that are or alleged child abusers, you know.
Where's Eli at? Where's that from Des
That's-
Moines?
As far as I know, it's about an hour and a half northeast.
Of Des Moines?
Yeah.
Okay.
Yeah, pretty far away, but
It's interesting to note some of these silly things. We have something called home rule, which means that local villages and towns and so forth can pass laws which are not already on the books as far as jurisdiction is concerned at the state level. I think that Eli or Ellie or whatever they call it, when the town council passed this law, they were infringing upon the jurisdiction of a law that had already been passed by the state legislature. So I don't think they can claim home rule and pass these laws in such a fashion as they have. In other words, we can't have conflicting laws. We can't have little counties and townships and local organizations passing laws like this at the same time. So we're doing a lot of silly things. By the way, this law, House File 619, $5.3 million to secure it now, that is, each year, grease it up and keep it going. But in 4 years, they will have to set up a budget so that they can pay out $12 million for it. Well, while we're talking about big numbers, let's really go to a really big number in this area. How about $1 billion for an organization called Violence Against Women's Act? VAWA, they call it, VAWA. And right now, we're in the midst of something called the
Sounds like something vulgar.
doesn't it though? Yeah, sounds like a body part or something, doesn't it? Okay.
Okay.
We're in the midst of something called the reauthorization of the justice system, and part of that is this VAWA business. And of course, if you're against anything that the women are for, that means that obviously you're against women. Well, and some of these women, I'm not sure I'd want to take much of an opposition to. Well, anyhow, about 10 years ago, when Bonnie Campbell was very active in this area, she went to Washington, D.C. and managed to put together something called Violence Against Women's Act. It was budgeted, at least at one time. It's probably significantly higher than that now, but it had a budget of $1 billion. Well, that's a pretty tidy budget. Our president has asked us for suggestions about how to reduce our spending so that we can offset some of the costs in the New Orleans problem that we have down there in the Gulf. I would recommend, Mr. President, that we shut down VAWA. VAWA is nothing but a troublemaking bunch of women that have all kinds of ideas and techniques to get across their agenda. Well, welcome to the official website of the National Task Force to End Sexual and Domestic Violence Against Women. You suppose they would ever want to shut down? I doubt it. Not if they've got $1 million budget. Please feel free to.
That was $1 billion.
It was. Did I say $1 million?
Yeah.
Yeah. I goofed.
Add some more zeros.
Yeah, absolutely. Please feel free to read through our recently updated summaries of Titles 1 through Title 9 of the Violence Against Women's Act, VAWA, House File 2876 and Senate File 1197. It actually, the funding for it came out to be House File 2403. And recently that went before the House for debate. And there's a lot of debates about how to implement this thing. When they go in for reauthorization, the reauthorization is set up for 3 years. So this will be for, I think this is supposed to be for 2006, 2007, and 2008. So they'll come up for reauthorization in 2009, I believe, again. Our other new link is writing to your representatives. So they're very active here, apparently, on the computer to get people to write and urge their representative to vote for another $1 million. When you stop to look at what they actually do, and maybe we'll have an opportunity to do that from time to time, you find out that it is not a good organization for keeping families together. They want to have such things here in Iowa. I know they wanted to have a shelter so that a woman who wants to kick her husband out doesn't have to travel more than 30 miles to find shelter, counsel, and care for her and her children. That
Well,
costs a lot of money
well,
for things of
nowadays
that
don't they
sort.
kick out the husband? It's from my. I know I've got some people I know um, where whereby they had gotten into a dispute with their wives, and regardless of who was at fault, um, they had kicked out the guy, and the house was in the guy's name.
He
So
goes to jail immediately, doesn't he?
yeah, and has nowhere to live when he gets out. So I think this is kind of a very weird twist. I mean, I could see if maybe if there was something that had occurred, and both of the parties had the name on the house. But if a guy has his name on the house, why are you gonna kick him out of his own house?
That's right.
That doesn't make any sense to me.
Well, when it comes time for stability of the children, I suppose it'd be the right thing to do to kick the guy out of the house. Except if there's violence, do you suppose that a woman could be a part of that? When you look in the statistics in the paper, and they don't publish these very often, it's the women who are fighting for divorce. So VAWA and these rightist women's rights organizations are much behind tearing apart the family. I looked at a list, the most recent list that I saw of divorces in Polk County. All of them were filed by the female half. Uh, if you look at it real carefully, you'll find that all of the marriages were filed by the male. Now, isn't that a strange arrangement? Males want to put the family together, the women want to tear it apart if it doesn't fit their current thinking. You know, for married, for better, for worse, for rich, for poor, you know, or until they find another man that will meet their needs. Well, we'll look into this as time goes by, but for right now, Don, I want to turn to you for a story from Colorado. This is one of those women's rights families where they lost the children to not domestic violence. They lost this to very serious criminal violence. But the woman thought that she can attach herself to the police department pretty much as though the police were a part of her family, or they had some kind of she had some kind of a right to direct their efforts. What happened in the courts in Colorado, Don? In this case, in Washington, D.C., because it went to U.S. Supreme Court.
But the family involved is in Colorado, and I remember hearing about this probably 5 or 6 months ago. It was talked about going to the Supreme Court, and how the police reacted at the time, or didn't react, is what happened, and should they or shouldn't they not have. So it all went to the Supreme Court, and because they didn't react, children died. This article says, in the courts, town of Castle Rock versus Gonzales. With its 7-2 decision in town of Castle Rock, Colorado versus Gonzales, the Supreme Court has further jeopardized the safety of the domestic violence victims. The outcome of this case raises important issues about the role of police in protecting victims domestic violence and about the effectiveness of protective orders. The Supreme Court determined Jessica Gonzales may not, and this is the mother we're talking about, may not take, missing an E on here, may not take her local police department to federal court. In other words, she can't sue them in federal court for failing to enforce a restraining order against her estranged husband, Simon Gonzales. On the evening of June 22, 1999, after Mr. Gonzales violated the order by taking the couple's 3 children, Miss Gonzales called the police repeatedly to demand enforcement of the restraining order. The police ignored her pleas, and in the early hours of the following morning, Mr. Gonzalez murdered the three children and then was killed in a police shootout. I think that was right in front of the police station. The police shot and killed her husband because they were now on the defensive. They didn't worry about children in the beginning, and then it got to the point where the police had to protect themselves, so then there was a police shootout. Well, that's the way I interpret it. Legal Momentum, the nation's oldest women's legal rights organization, disagrees with the decision and believes that the Constitution requires police to make a fair inquiry into a situation before it denies the protection that victims are entitled to under state law. Without proper police enforcement, protective orders are merely pieces of paper that may even serve to incite abusers' anger. By the very act of seeking protection, abused women sometimes put themselves in jeopardy. That's true. So a woman should maybe think twice before going out and asking for protection from our government. It goes on. That risk is heightened now that the Supreme Court has refused to hold law enforcement officers accountable for enforcing orders. The world has recognized that women and children are entitled to government protection against family violence, said Jennifer K. Brown, Vice President and Legal Director of Legal Momentum. Quote, our Supreme Court has permitted police to make a mockery of that protection by dismissing women's pleas for help. Legal Momentum filed a friend of the court brief arguing that the court should consider international law in deciding the case. Recently, the court cited international human rights standards to strike down the juvenile death penalty in Roper versus Simon. The Gonzalez brief points to treaties, laws, and court decisions that entitle women and children to government protection from domestic violence. U.S. ratification of the International Covenant on Civil and Political Rights, which requires governments to afford this protection, is especially significant because under our own Constitution, ratified treaties form part of the supreme law of the land. I'll make a comment on the what I just read there, talking about treaties, laws, and children to enforce government protection from domestic violence, U.S. ratification. Let me start there. U.S. ratification of the International Covenant on Civil and Political Rights. What do we need to go to? An international deal to protect us. We should be protecting ourselves right in the United States without going to another. Well, we might go to Europe or Russia or something for protection. No, we should stay in the United States. Anyway, the document goes on. In Roper versus Simons, the Supreme Court gave life to international human rights standards as it interpreted our Constitution, says Ms. Brown. The court owes no less to abused women and children when it comes to their constitutional rights. John or Terrance, did you have a comment on that?
Yes, I thought it was rather ridiculous that this woman. Sure, it's sad that she lost her children. It was her husband that should have been protecting those children, and I don't know why he was thrown out of this family. Like you said a moment ago, it's the father that gets kicked out of the family, even though the father it may be his house, but that makes no difference when you.
Yeah, but if you got a man that's willing to kill his own daughters, there's something wrong there too.
By all means. That isn't the issue that I was going to look at it at this juncture. The whole idea that a woman can go down to the courthouse, can, without an attorney, file papers, can get advice from the clerk for this area and this area alone. The clerk cannot advise anybody on anything legal except in the violence against women's
And they're good
area.
at that.
So they can sit down there and act like attorneys, and they are required by law to do so. And they can file their papers without filing fees. And for some reason, the judicial system in Iowa said they couldn't understand why there were so many filings in this domestic area. Well, when you make it free, and then what they also want to try to do is they want to add the police protection also for free. So anything the woman wants to do, she can call the police if the husband drives past the house, and I've heard that happening.
But in the court story I just read, she called the police,
Yeah.
and they didn't do nothing.
Well, the police can act when there's a probable cause to act.
And I guess they don't have to act if they don't want to act.
Now, if you want to patch up this business, tell them they've got to pay a filing fee like everybody else. Tell them that they don't get any legal advice from the clerk of court. That if they want to file a legal paper, either read up on how to do it or get a lawyer like anybody else has to do. Then they need to post a $1,000 bond if they intend to keep calling the police, because we have to pay for police protection. We don't think we should give that away to the women. So.
And I had somewhat of a little bit different view. I think that it's all good and fine that women have great protection in these sort of incidences, but I think a lot of times in cases that I'm familiar with, I actually see the whole idea of the no contact order being used in somewhat of a vindictive fashion instead of something that has been something that is seriously needed. I know that there's instances in which they have been needed, and that's fine. But a lot of times the court doesn't do enough investigation, I think, or the whole process doesn't basically allow both sides of the story into. I mean, they can actually file these applications for no contact order and get them granted. For the most part, ex parte. You have to go in. I think the process is you have to go in and then sort of defend the allegations or somewhat. But 9 times out of 10, the judge is not going to cave into the guy's side. He's going to cave into the woman's side.
Well, it's all ex parte anyhow.
Because this is a big guy. And if you're a black guy, oh, that's a big black guy, and I can believe that he's very violent. When in reality, the broad scheme of things, it's just a bunch of bullarchy. It'd be stereotyped in such a way. It doesn't make any sense. So I think to even the score, if they're going to make this fair, let the men go down there and file for a no contact order, and for once take them seriously, because statistics show that women do instigate and start in most of these fights, and they may not be as big in a lot of instances as to inflict serious injury, but when you got a woman that has long nails and scratches and bites and throws things, kind of even score in a lot of incidents.
That's right. It's interesting, there was a program one time, a very interesting program called The Honeymooners, Jackie Gleason. Jackie Gleason would be in jail if he were to do the things that we saw him do on his program, because he would double up his fist and tell Alice, one of these days, you're going to the moon, and pow, and he would threaten, he would holler, he would do all kinds of things that would be considered domestic abuse in today's world.
He'd be
And
under the jail.
that's right. And they can send you to jail, put you on a $13,600 bond, and then how in the world? And of course, put you under no contact order. So when you do get out, you can't go back and get your clothes, get your pets, get your tools, and get your pickup truck, because your ex has already sold the pickup truck, and sold your dog. So the poor fella that gets socked into jail like this. And then I've even heard of them, coming home from a jail term like that. One fella in Cedar Rapids came home, went in the basement, and he was so mad that he threw beer bottles against the wall and broke them. They could hear the glass breaking, so they had him committed for 4 days. So
Isn't that better to go down to the basement and do that than to take it out on your wife?
I would think so, but they didn't see it that way. So he served time in jail, and then when he got home, he served time being evaluated. Well, he was okay, but he needed evaluation because of the comment or the complaint of a woman. Women are great, but I think they have organized in such a way as to tear up the whole concept of the family. I'm going to turn to Terrance Walker right now. Terrance does a lot of research in this area of the courts and some of the things, some of the struggles we have simply because the courts don't work correctly. Terrance is the head of an organization called VIJO, VIJO. Has to do with determining whether or not we want such things as judges to continue serving. Let's throw the judges out if they cannot perform correctly. Right now, Terrance Walker.
Well, thanks a lot, John and Don, for having me on the show again. I guess am I officially a regular now? We went through this last week. But my name is Terrance Walker. I'm the judge of the judges here in Iowa because, like I said last week, nobody can do it better. We've got a couple cases here I wanted to examine for you. I think that in examining the judges, we've got to examine their cases and see how they're doing. 2 cases, or 3 cases, actually came to light today. There was a case that was filed in the Court of Appeals for Iowa, State of Iowa versus Tracy Lee Johnson. And these cases, if you're not familiar, they're all available on the Iowa Supreme Court website at judicial.state.ia.us. And I'll say that again at the end of the show so you can go get these cases. Here's a relatively short case, and I think this is the epitome of the rubber stamp. You guys know what a rubber stamp is? Don or John? It's where they just basically
They rubber stamp it, they say.
They just look at it and say, okay, this lady filed an appeal against her conviction to the Iowa Supreme Court.
But we'll take your $100 filing fee.
Yeah, they'll take your money, and the lawyer definitely is not going to refuse your money either.
No way.
But here's what you get for all your thousands of dollars: the rubber stamp. And if you look at the bottom of this page, therein lies the opinion. And it's a per curiam opinion, which means one of the judges, I think, it means one of the judges decided it. Per curiam. 3 judges on here: Judge Hutink, Vogel, and Zimmer. And if you get an opinion by Hutink, you can best believe that it stinks. This is Judge Hutink, Judge Vogel, and Judge Zimmer of the Iowa Court of Appeals. It says Tracy Lee Johnson appeals his guilty plea and sentence to the charge of aggravated assault in violation of Iowa Code Section 708.1, 708.2, arguing his counsel was ineffective. After careful review of the record, we affirm without opinion, pursuant to our rule of appellate procedure 6.241. Wow. Is that what you guys got your pay raise for? To rubber stamp more appeals? You know?
Not much explanation there, is there?
Well, you know, when you can sit there and you make up these rules that allow you to do whatever you want to do and not do any work, except for look at some papers and maybe rubber stamp something in about 2 or 3 minutes, that's what you get. Another opinion here that I thought was kind of interesting. State of Iowa versus Blaine Freeman. This is filed September 23rd of this year by the Iowa Supreme Court. And, you know, I always criticize these judges. One judge stands alone on the Iowa Supreme Court that I think is actually doing his job really good. David Wiggins. Justice Wiggins actually reversed this guy's sentence. So we got to say bravo. But if you look, we don't have a lot of his opinion in there. This guy basically was convicted of 3 different crimes. None in order of succession, basically. One didn't precede the other, I should say. But if you look on the next page, here's the guy that had to disagree with Justice Wiggins. His name is Justice Carter.
Dissenting opinion.
Dissenting, mean he disagrees. I respectfully dissent. And he's arguing, and let's look at this language. He's arguing that in order to get this enhanced sentence, one does not have to get convicted by have a previous conviction, which the statute clearly says you have to have 2 previous convictions. Okay, well let's look at the part where he says the relevant language of the statute now before us states. A person who commits a violation of this section and has previously been convicted 2 or more times of violating this chapter is guilty of a Class D felony. Okay, now what do you guys think this means? Just from
Exactly what it says.
okay. So
1, 2,
what
3.
happened? What if this guy got convicted September, got convicted in October, and then got convicted in November? Wouldn't he be under this statute?
If it fits the crimes that are mentioned here,
Yeah. So
this chapter.
all right. Well, what this guy's saying is basically, and he's ignoring the whole language of this. This is what really gets beyond me, is how you have guys on the court and women on the court, for the most part, that can't understand grammar. It says a person who commits a violation of subsection has previously been convicted 2 or more times. This judge is basically arguing that, well, you don't have to be, the conviction doesn't have to be in place before you actually can be lumped in this category. He's arguing the guy had, since he had some stuff pending that wasn't a solid conviction yet, he's arguing that constituted the 2 convictions.
Previous
You know?
means previous.
Previous means previous. And he goes off on a tangent and he argues his point illogically and in disregard of the clear grammatical text of the statute that this is the ironic thing. He states the meaning of these words is crystal clear. They convey the message that if a person who has violated subsection 5 has previously been convicted 2 or more times of violating chapter 124. No, it doesn't make any sense. There's absolutely nothing contained in the statutory language requiring the prior convictions be in any particular order with respect to time of preparation and time of conviction. Yeah, I think you contradicted the whole meaning of the statute. And as you state, the meaning of these words is crystal clear. How come Justice Carter can't understand this? If they're not, if he says they're crystal clear, But obviously, he has no basis for saying what he's saying. Previous means previous. But this is what kind of justice we get here in Iowa. Very little, which is why we are advocating a lot of these judges, especially all on the Supreme Court except for Justice Wiggins, to be voted out. Because this is the kind of illogical nonsense that they try to perpetrate and try to enhance these criminal statutes, and when in actuality the Constitution says that criminal statutes are supposed to be interpreted leniency, especially if they have any hint of ambiguity. Well, at best, the statute is ambiguous. I don't think it's ambiguous at all. So tie goes to the defendant. You know, can't these guys figure this out? Elementary constitutional principles, totally devoid of understanding of them. This is what I'm talking about. This is why we should get these guys out of office. This other case I thought was also interesting here, that I have Fidel Manriquez, State of Iowa versus Fidel Manriquez, Iowa Court of Appeals, September 28th as well, 2005. This guy was convicted of possession of a controlled substance. Okay. The background. In the evening of August 4th, 2004, police officers Joe Fuentes and Chad Nicolino noticed a pickup truck with a burned out license plate light driving south on 2nd Avenue. Officers activated the emergency lights on their patrol car and followed the truck. The truck did not pull over on 2nd Avenue. Instead, it turned on the side street and pulled into a parking lot behind a business. There was no street lights in the area where the truck stopped. Well, these two guys, Jose Hocavo and Manriquez, they exited the vehicle before the officers pulled their patrol car into the parking lot. And they eventually got the guy to give him his correct name. I guess he gave him a fake name at first, and then he gave him the right name, and then they found 2 warrants, and then they patted him down and searched him and found the illegally controlled substance. Well, on appeal, he argued that, Manriquez argued, that the search, the initial stop, was not up to code or not up to standards of the 4th Amendment. He says that the police did not possess a reasonable and articulable suspicion of criminal activity to justify the search and seizure. Well, I think he has some legitimate concerns. There's a lot of people that have burned out lights. Are we to give officers the full right to just stop anybody, even if their license is up to date? But they justify this by saying that, basically saying that, well, even if there was a 4th Amendment violation, the evidence would still be admissible because it would have inevitably been discovered. And I think that is just such a crock. They first off didn't even examine whether or not the initial stop was justified. They basically jumped over that argument and just went ahead and said that it would have been inevitable. How can you say it's inevitable if the stop wouldn't even have happened? You know, this is the same kind of illogical crap that goes on in the Iowa Supreme Court, and it needs to stop. That's why we need to vote these judges out. And this judge that wrote this opinion, Judge Zimmer, I tell you, the chances of getting justice are slimmer if you have an opinion by a Judge Zimmer. And he wrote this opinion in this case, despicable, despicable. Some article here, Detroit Free Press, judge found guilty of misconduct in the parking dispute. This comes from the Detroit Free Press, Monday, September 26. Calling him an officialist intermeddler, a retired judge on Monday found 36th District Court Judge David Branfield guilty of judicial misconduct for assaulting Detroit's deputy mayor in a dispute over a parking space. How do you like that? Visiting Judge Richard Ernst, retired from the 23rd Circuit in East Tawas, issued the ruling Monday. Adams was sitting in his car outside the 36th District Courthouse in downtown Detroit in a space reserved for judges when he said Bradfield drove up, cursed at him, and told him to move his car. According to the complaint, when Adams got out of his car, the judge grabbed Adams' shoulder, yelled at the deputy mayor, and poked his fingers in Adams' chest during the incident. Adams was at the courthouse to meet his wife for lunch, who was District Judge Deborah Adams. How funny. Upon observing Mr. Adams exit his vehicle and approach the judge's door, Judge Bradfield became further incensed and rushed to intercept Mr. Adams, physically grabbed Mr. Adams by the shoulder, poked him in the chest several times, and offered to fight. Can you believe this? Well, he's got 28 days to file objections to the report of the Judicial Tenure Commission, which will then schedule a public hearing on the report and what sanction it would recommend to the Supreme Court, if any. Well, that's too bad that we don't have a judicial review process like that here in Iowa. And speaking of which, our own John Harvey submitted a complaint. You guys probably remember the incident here that the
I'm just a messenger.
Pierre Pierce trial about 2 months ago. FEJA representatives, Fully Informed Jury Association, were handing out informational leaflets to potential jurors that were going to preside in the case, basically. And they were met with hostility for providing, basically, informational materials to the jurors before the trial.
To educate them.
To educate them on the roles of jurors, constitutional role. You know, how was that harmful? Well, but the thing is, what happened is, I guess the prosecutor must have been outraged that his jurors were going to be educated.
The judge was.
Well, he must have had the judge get enraged too, because he came out and he was livid. Well, why are you guys are poisoning the jury? Granted, the jury hasn't been impaneled yet, and I'll just read this complaint which John Harvey submitted along with Dale Lawrence, who is a FEJA representative, to the Judicial Qualifications Commission here in Iowa, and we'll follow up on this to see if they do anything. My experience with the Judicial Qualification Commission is they're just a puppet organization of the judicial branch, which is, I mean, they don't do anything that I am aware of. I think they've only kicked off in the past 30 years, recommended for removal, maybe 1 or 2 judges that I know of.
Is that supposed to be funny?
Well, it's not funny at all. You know, it's funny that they haven't done it, but it's not really funny, if you know what I mean. I'll just read off some of the complaint. The events, I'll start when you're talking about the events here. The events about which the undersigned makes complaint occurred on the 15th day of August 2005. The events about which the undersigned complains occurred on the above dates in the matter State versus Pierre Pierce. The said matter was in District Court, State of Iowa, in and for Dallas County, and it has a case number. The events about which the undersigned citizen complains are as follows. On Monday, August 15th, 2005, on the public sidewalk, immediately adjoining the west boundary of the Adel, is it ADM?
ADM,
ADM High School in Adel, prior to judicial session, in which jurors were to be selected. Frank Brown and Dale Lawrence, state officers of the Fully Informed Jury Association, were peaceably distributing FEJA literature to passers-by and to individuals who were summoned as prospective jurors in the matter of State versus Pierre Pierce. During the course of that First Amendment exercise, the gentlemen were abruptly confronted by Judge Gregory Hulse, and I call him No Pulse Hulse, because in front of Judge Hulse, obviously, the idea of justice is dead. The judge instructed the pair to cease distribution of an informational leaflet that was intended to enlighten citizens regarding their duties and responsibilities as citizen jurors. His demand was made with an elevated voice and a strong threat of reprisal for failure to obey his instructions. Freudian slip, obstruction. He used finger gestures in close proximity of the face of Frank Brown to add emphasis to his orders. He told Brown and Lawrence that they were poisoning the jury. Keep in mind, the jury hasn't been impaneled. The judge said that Brown and Lawrence did not know what they were doing. While his utterances were somewhat confusing, he left no doubt that he wanted no further distribution of Fiji leaflets. Holding up a copy of the leaflet, he stated that the Fiji representatives were causing him a lot of problems in there. He pointed out that the leaflet mentioned another case of burglary in which the defendant who chose to visit his ex was charged and sentenced to 25 years in prison on the pretext that the visit constituted burglary. Now, this was a case out of Cedar Rapids, and this leaflet had an article from the Cedar Rapids Gazette which talked about this case, and the guy had went into a party. He didn't go burglarize, so to speak, whatever they call burglary these days. He didn't go over to the woman's house. He was at a party where he seen it.
The incident, I think, was Eagle Grove, but
Yeah.
it's reported in...
And he was wanted at the party. They testified they didn't mind him at the party. The jurors in that case were not aware of the magnitude of the penalty for the offense they were called upon to deliberate and render a proper and just verdict. It was a reference to a similar case that miffed the judge. When it was explained that there was no reference to any litigant in the case, the judge, or litigant in the instant case, the judge said the reference to a similar charge in another case was impinging on the facts of the Pierce case. Okay, that's confusing. Upon parting, the judge said, "Follow my order or I'm going to have you locked up. Believe me. Believe me." He then made reference to his order and reiterated the threat of severe punishment. His demeanor was coarse and his temperament was clearly unfettered. His attack was deliberately intimidating, abrupt, demeaning, threatening, absent proper decorum, and his actions in making such a ruling served as a direct violation of First Amendment rights of the complainants. I think that has a lot of merit right there. And I'll let that go from there because we're almost out of time. But I do think that you put that in very eloquent wording.
Okay. Well, that's what should happen to all judges who misbehave. It should be brought to the attention of the Iowa Supreme Court, the ethics portion of the Iowa Supreme Court.
And to us.
Just to check up to see if there's such a thing as ethics left in the Iowa Supreme Court. We'll be very careful to follow up on that and let you know if they can prove Terrance to be totally wrong. I think it would be great if they proved Terrance wrong on his attitude toward the Ethics Commission. I hope that they discharge this judge. I think it would be a good signal for the citizens of Iowa. I want to thank you for watching the CPI report. We'll see you next week.